Ahora es para esto. Give. Dismiss. Give. Withdrawal. Always welcome. Give. Hearing matter, extension of interim order.
Tender matter face.
Only extension. Give it for extension only. Fresh matter. Give. Why you are anything? Give all the slip, all the memos. No hearing matter.
My lord, my lord, may I most humbly, my lord, trouble your lordship with respect to item number 46. My lord, this is that tender matter, my lord, with respect to supply of, my lord, ultrasonography machines. My lord, now from yesterday, my lord, they have started, my lord, the work orders have been started to be issued. And your lordship's last order was, my lord, that they have every detail with respect to their opposition, my lord, ready. But till today, my lord, they have not served us a single copy about whatever their opposition is. So, my lord, there's extreme urgency now.
Let us see. We'll reach the matter. Don't worry.
If the matter is not reached, may I, my lord, trouble your lordship at the rising, my lord, so that I may come tomorrow physically.
Let us see. It will reach. Why you underestimate the pace?
My lord, I never underestimate your lordship, but just a caveat, my lord, or a precaution.
Come. Let us see.
Grateful, your lordship. Extremely grateful.
Lordship, item number 43. Item number 43.
Withdrawal. Take it. Yes. Don't worry. Why she is thinking?
Item 45 is a matter regarding admission for the nursing courses or renewal of.
Let us see, sir. Let us start the roster so that we can reach 45. Don't worry.
Item 51, madam. Item 51.
Let us see. Let it be called.
Given for withdrawal.
Withdrawal always. It will be at the top of the list. Don't worry.
Item 51 permitted to withdraw, madam.
Yes, please.
Already filed, madam.
Yes.
Item 51.
Thank you.
52. Ma'am. Case admission item number 1. Item 1.
Last occasion, lordships are dedicated to communicate whether the payment has been made.
Payment has been made, my lord. Petitioner's dues have been paid.
Yes.
No, all dues have been paid.
Item number 2.
Yes, sir.
My your lordship. My lord, the petitioner, Supriya Naik, whose father died,
What is the order you are complaining of? This is a contempt application.
contempt of the honorable
Where is the order?
single judge.
Which order?
Or she means right.
Perhaps.
What is the order of the division bench?
Division bench, a single bench.
Can a contempt lie before the division bench? asking you,
Section
sir.
19. Section 19 of the Contempt of Courts Act says that against the order of the single judge, one can prefer appeal
I am asking you, sir, where is the order of the single judge? I mean, the ultimate order which you are challenging, how can you challenge the order of the single bench?
My lord, it
It
is
must be an appeal, writ appeal. You are filing a contempt application.
contempt of appeal.
Alleged appeal.
Contempt of
Is
appeal.
appeal.
Yes.
Okay, where is the order of the single bench?
Single bench which is annexure 5. Annexure 5.
Yes, that is the order you are challenging.
My lord,
Yes, let us just consider.
and also
Just 1 minute.
on page 18.
Mr. Nayak, please.
Where is the order dated 11/8?
1118 will say I have annexed as a annexure 9. Annexure 9 of this petition. Because I have filed a
No, please. Where is that? Connection 9 is not getting it.
I have filed a amendment petition
11/8 order is the
Right.
next page.
begging permission that annexure 9 may be
Fine. Sir.
It is might have page 20 annexure 2. You wrongly might have been saying that annexure 9. It is annexure 2 page 20. The order dated 11/8/2023.
Yes, so the board was directed to consider your case. Has they considered?
considered, means the consideration was in the year 2024, but the court directs annexure 2, your lordship will be satisfied if your lordship will go to annexure, verify annexure 1 and 2. Annexure 2 is a direction by this Honorable High Court in the year 2016, that within 2 months.
Sir, 2016 within 2 months. Then you filed a contempt application in 2017. That contempt was distributed on 11/8/2023, directing the board of officers to consider your case. So this is really a superseding the earlier order. Correct? Now that order is no longer there. Now this order has been substituted. Now what is the grievance in this context?
My grievance is this: whenever petitioner's father died, when he was working as an army.
We are not concerned with the merit.
No.
We are simply concerned whether they have already taken a decision for appointment under the rehabilitation assessment scheme. Have they considered your case?
Yes, ma'am.
Consider that where is the contempt?
My lord.
It does not mean that they have to consider favorably. It does not mean so.
My lord, only grievance is when the board decided my case, they rejected the application of the petitioner.
Then you challenge that order in another.
No, another thing. whenever my case is a case of 2015,
Whatever be the reason, correct order, wrong order, whatever be the reason, it is an order which is passed. You can challenge that order before the writ court. How the contempt lies, I am just asking.
section 19 says against.
Show us the section 19, let us understand the law. Give it. Give it. Let us understand the law. Give him the book. Tell me. First thing is we'll have to understand it is a civil contempt or a criminal contempt. The civil contempt.
Civil contempt.
Correct. Section 90, easy. Is a right of appeal. Go.
Section 19 appeals.
Correct.
An appeal shall lie as of right from any order or decision of High Court in the exercise of its jurisdiction to punish for contempt.
Correct. How section 19, I am just asking you that section 19 is the remedy by way of an appeal. No doubt about it. First thing is you have to satisfy that this is a contempt. If it is not a contempt, then what will it?
My lord, paragraph 1A is
In section.
subsection 1 of section 19.
Correct.
It is said like this is anybody will be punished here.
Sir, the difficult
But A,
is right of appeal
my lord,
and the entertainability of an appeal are two different concepts.
my lord,
They have a right to appeal, but it does not mean that the appeal has to be allowed.
where the order of the order or decision is that of a single judge.
A cannot be dissociated from the substantive part, sir. Once you are entitled, then only A will come. First satisfy the substantive part.
My lord, the single
Is
judge.
there any contempt there?
My lord, the
The
single.
contempt was dropped.
The single judge has committed a mistake by encouraging the contemptness, because whenever stipulated time was there for 2 months to dispose of a.
Why you did not challenge that order of 11/8/2023? Why? What you are challenge, what you are arguing, you could argue in that appeal.
My lord, I have challenged 2 orders.
Which order?
11/8.
In one appeal. Now tell me,
No, in this
independent orders can be challenged in one appeal. Now I'm asking.
In one appeal, the same judge has a direct.
I am asking you, sir,
Sir,
2 independent orders, whether can be challenged in one single appeal.
not a. What your lordship said.
Say it is not a law.
My lord, liberty was granted by order dated 11/8.
In 11/8/2023, the court has already directed the authorities to consider your application as a special case. You said that the authorities considered my application.
By that order, the authority has not considered my case.
What?
No. By that order, the authority did
By
not
that-
consider my case.
If by that, the
What?
authorities did not consider your case.
No, my lord. In that order, authority did not consider. Whenever I filed a IA, in the second order. In the first order, my lord, 11/8/2028, it was disposed of. and directing me to take appropriate action. Granted, leave is granted, liberty is granted to the petitioner to agitate this matter. So I agitated secondly on 11/7/2008.
11 October order, August order is not that what you are saying. 11 August order says this court is hopeful that instead of waiting till April 2024 as indicated in the additional affidavit dated 14/7/23, since the application of the petitioner is pending since 2016 as a special case, the authority concerned would do well to convey the board of officers to consider the case of petitioner for appointment under the rehabilitation assistance scheme at the earliest after supply of documents by her as indicated above. This is what is the only order which is passed. So you say that the board of officers, they considered your case
Considered my
but rejected the application. Is it a contempt?
Is it a first? Yes, of course, it is a contempt.
It is a contempt.
My lord,
I have to
my lord, why I am
afresh.
my lord, why I am saying that they have
Sir, the court has not said that the officer will decide the application in your favor. Can a court say so?
no.
The court simply said, decide the application. That's all. Now freedom is with them. They can allow, they can reject. They have taken a decision, rejecting. What is the contempt?
My lord, what was the duty of the single judge? Whenever sufficient time, more than sufficient time, allowed to
I am
them.
again saying that 11/8/2023 order, you are not assailed. What would have happened to this? Tell me.
My lord, 11/8/2023 is the order of the single judge by allowing 6 years time. That should not be done.
Sir, have you challenged this order? I'm asking you, sir. I'm asking you a very, I think, very innocuous
My lord,
thing. You are either not consciously answering it
my lord.
or deliberately avoiding it, or third, I am not going to say.
I hope that your lordship may issue notice to the opposite parties and hear them first.
Yes, sir. Because I
IA for.
Yes, that is good. 500 million.
Then transfer होगा TANDON connected. This contempt as option file not.
Mr. Raj, you have IA 447 of 2023 copy, please. Please hand up.
Answer 5 minutes.
IA number 447 of 2023. In your contempt, you have filed this. Please,
I'm sorry.
please pass. Petition, sir. Petition, yes. You have filed that petition, it's supposed, please.
Any other data will show it. Hello, dear Lordship, may see the order of the Honorable High Court.
Right.
Not calculate the beneficial for the first order. This is started calculating from the last order. How? Who is the person? The reporter is
now.
Since this subsequent, I will do something. So it was.
Next basement.
You should play it. No. No. You never.
That is on this. This one.
Here, this is no. 11th one. What the matter of the thing wanted to be recalled. Oh. Yes, sir. Tell me, two orders can be challenged in one single appeal? No.
The same judge, the same single judge.
Suppose then very interesting point you are raising. Be the same judges, we disposed of 20 matters per day. So one appeal challenging all the 20 orders are competent. No difficulty. Same judges. 20 appeals are not required. One appeal, all 20 matters, all 20 orders. Sir, appeal is against an order, not against a judge.
No, I am not going to. I'm
So
challenging.
if the judge is passing an order and he further is independent, then will you not file an appeal against each independent order?
Both are independent.
So can single appeal lie?
Only can it be like?
It can lie. Ask judgment of any court or section 19 you quote. I will be happy in your favor. I will go in your favor.
It is a continuous order.
Continuous.
Continuous order.
So according to you, suppose in the suit for partition, there are two stages. One is a preliminary degree, another is a final degree. So it is really a continuation of the suit after preliminary degree. So if you challenge a final degree, you can also challenge the preliminary degree. It's a continuation of the suit. Correct? CPC says otherwise. That you cannot reopen preliminary degree. It's an independent degree. Maybe in the same suit.
This court has ample power to accept one of the orders if your lordship desire.
Then we are taking 11-7 order. Last order.
Yes, your lordship will take it.
No question of recalling an order. Fair enough. We are going by this. Yes. No difficulty.
My lord, if your lordship will be satisfied to issue notice to the opposite at least. Your lordship,
Sir, the subsequent order
poor girl,
is really a recall.
Poor girl deprived of her.
I tell you very frankly, empathy, sympathy, can it come in the way of a dispensation of justice? Can the law be whittled down, erased on the ground of sympathy? I understand that your client is really pressing upon to have the appointment into a job on the ground of compassion. But law has to be respected, law has to be taken. If the law does not permit, will the court pass an order beyond the law? Can also the court direct the authorities to act in violation of law? Can the court pass? How can a court say that you act in violation of law? Court cannot say so. Only court will say you please act in accordance with law. Respect law, do it, but not violate it. I think I have been more composed for this matter, which does not require any consideration beyond 30 seconds.
If your lordship desires to dispose of this matter, further chance may be given to the board. The board will consider her case.
Sir, the board has decided in this way or that way. It gives you a fresh cause of action. Can you come in a contempt? I am asking you, sir, very humbly, in respectful manner, I am asking. You are a lawyer. You are supposed to argue the law. Please advise the bench what is the correct law. Can the court do so? I am asking you.
My grievance in this respect, that since the single judge has allowed the matter for a period of 6 years by passing order on 11/7/2024 and 11/8/2023 for a long period, that is injurious. That was injurious to the petitioner. That was injurious for the petitioner.
Then what the petitioner will do?
So,
What the petitioner should do?
My lord, the two orders was passed against her in her favor. Annexed one is the AFD Kolkata passed order that you consider her application within 6 months. And the second annexed two is the order of the High Court within 2 months. But both orders are become defunct. So she has been
They
harassed.
have ultimately considered your case. Have they not considered, not within 2 months, whatever, when the court did not punish him, that means the court has considered an apology or have considered the explanation for delay. But the decision has come. It is not that the decision has not come from the board of officers. You yourself is saying that they have taken a decision, but rejected your application. At the very outset, he must record for the purpose of
another thing may be recorded. My submission is recorded that
I have recorded all your submissions.
liberty, if any further application will be made, that will be considered by the board. Board, it was the decision for the year 24. Every year, board is sitting, every year, 24, 25, 26. But if I was eligible to get the selection, for the next year, they will consider.
Question does not arise because already you were rejected. That question does not arise because already you were rejected. We have considered this time, rejection has been passed. The question of considering does not arise by.
This will be done, at least the.
Since we are live streaming, I can't say, but there I always say one sentence. So I restrain myself from saying one sentence, which I utter for this reason, on this incident or officer, when this kind of submission are made.
Yeah.
To delete the order regarding cost.
Why not?
How the poor lady will be. So that is your lordship say. This
That is what I be exercise discretion. If for judge exercise discretion, say that it is wrong. Discretion is always there.
Let it be that should not be taken place in the order.
Why? Why? Why, sir? Not be taken place. So the next
Item number 3.
Non-compliance of the order, especially 1/9/2023, division amendment, that is on page 8, madam.
we have deleted. Tell him. Cost being taken. Yes. Yes, sir.
The non-compliance of the order dated 1/9/2023, page 8, Cartwright division bench, that is WPS number 20,631.
Deduction, sir.
The dispose of the annexed 5 minor.
Have you disposed of the
Representation, my lord, I have received some inadequate instructions, my lord, one short addition.
this is a contempt, sir.
It is, my lord, but
No, sir.
direction was for. So, my lord,
Service. Sir, no.
Yes, ma'am.
yes, the copy I have, copy of the representation I have.
Affidavit 82. I mean, 1 week after the new thing,
No.
if you are believe 1 week thereafter. Contempt to be listed after 3.
Right. Item 4.
The prayer, the petitioner, to give you direction to implement the Annex 2 of the Patent Rights Chapter issued by the Government of India.
I could not get it.
What?
What you say? I could not get it.
Yes,
What?
they have received in 19.
What you say? What you have said?
They have
Public interest litigation.
that Annex 2, your lordship can see Annex 2 as at page 31, 39 to 41.
Yes.
The Government of India had issued that annexures, that letter to all states, and invented to this, to implement the patient right charter.
To implement
To implement the patient right charter.
patient right
Right
charter.
Yes.
Then
Then he has not implemented this. And on Annex 5, we filed several applications before the Chief Secretary and Secretary Health. They have not acted upon that, implemented that annexures, that letter of the state central government. And thereafter, lastly, on Annex 5, he issued a letter to us that writing that I have issued letter to all collectors to implement the patient right
but
charter.
there is a decision, though, so why you will not, it's a patient's right. The charter.
Now let's me see page 56. Here, my lord, the Directorate of Medical Education, DMET, they have written to all the collectors to implement that, my lord, the directive of the central government, and my lord, to furnish an action taken report. But my lord, the Directorate of Medical Education, they got their own panel, and they have not been made added as opposite parties to the writ petition. So I think it proper, my lord, because they have their own lawyers, my lord. My lord, if they include DMET as a party, they can furnish. Secretary of the party.
Welfare.
My lord, I'll take instructions from the department.
It's not, it's easy to see that.
Yes, my lord.
They are all under you.
Yes, my lord.
They are all under you.
I'll take instructions from the
And
department.
say that immediately display in the panel.
Yes.
My lord, my lord. I'll take instructions on, my lord, from the department.
Chief Secretary is the.
Yes, my lord. Yes, my lord. But my lord,
On this. Why are you,
no, lord, I'll take instructions from the department.
Others who are not doing.
No, lord, this letter has been issued by DMET. That is, my lord, page 56, my lords will see it has been issued by the DMET. That is what, my lord, I was saying. Because action taken report is to be furnished to the DMET as per this letter.
Sir, then this whatever, the DMT is not under your surveillance or under your.
They've got a separate panel of lawyers, my lord.
Sir, I am not asking. Then what for the government does?
I'll take
Health
instructions
sector?
from them.
Are they not taking care of every the hospitals?
My lord, I'll take instructions from the health department.
Why we will go for chase each and every?
My lord, think proper.
It is you who have to make a direction.
I'll get instructions. I'll get.
Once you have issued a letter, whether it is complied or not complied, it
That
is
is
not
you,
taken
sir.
forward.
My lord, I'll get instructions. My lord, keep it short.
We do not ensure this letter of yours is complied in letter and spirit.
My lord, I'll obtain instructions. I'll obtain instructions.
Following the directives.
This is a very important aspect.
I'll obtain instructions from the department, health department.
How can one show complacency in this return?
My lord, I'll
Just issued a letter and then you slept in the slumber.
my lord, let me find out, my lord, what steps have been taken. My lord, I'll get back.
Okay, 1 week
My lord.
to take
No.
to respond.
Item number 5.
Oh, you have raised the Rajya Rogi Adhikar Mancho?
Yes, madam. Because the month was formed. The month was formed for the benefit of the patient's rights, working for the patient's rights.
Yes.
Item 5.
Yes, removal of the unauthorized occupants.
My lord, sir, I've got instructions, my lord, an encroachment case has already been initiated. My lord, they have also, my lord, given them an opportunity of hearing. My lord, they're praying for 1 month's time to dispose of the matter.
Okay.
The private opposite party number 5 has been noticed, and he has that the private OP5 has paid for some time. Therefore, my lord, they prevent some time to be granted by this honorable court for disposal.
Without entering into a arena of the
Item number 6.
Action of the revenue authority is not initiating the encroachment proceeding against the government servant. And the government has also given a patch of land, his forest land, and he is constructing over 2 crores. That's under the consideration before the revenue authorities. They are not
PIL.
Yes, no, that's they are not taking any action.
So PIL.
No, once depending, they are not
You are a citizen of the country, you have a right to make a complaint to the government if there is any violation of the law. If that being the position, PIL.
Considering the demands of the public. And there his
I think the concept of PIL has been completely shattered here. It should be for a very good and good cause and for a larger section of this peoples of the state, but not in this fashion. The personal enmity, the personal issue, the personal things have to be, these scores have to be settled through PIL.
on government
In earlier matter, I have already said, you can ask for a mandamus. What for under Article 226? 4 kinds of writs.
See, government is encroaching the land, and
Maybe that's a violation. You can ask for a mandamus.
that's the grievance is pending.
The advance is yours. You are a rightful citizen. You have flagged that your land is being encroached.
No, not my land. That's the government land now.
Your land means the government
Yes,
land.
yes.
You have flagged an issue to
Forest
the
land has
government
been provided by the
that your land is encroached.
land. It's not encroached. And my
That is
lord,
what you say. We do not intend to go.
Let's kindly have a glance at the prayer, my lord. The second prayer, direct the opposite parties for cancellation of the RORs. My lord, my submission is for
I
cancellation.
just wanted to know, is it a government land or it is a forest land or ROR stands in his name? In the name of the
OP floor.
That the nature of
That's
the
a fine.
ROR is in his name.
Yes.
ROR is the
Then
Oh,
can
One,
you have to go for cancellation of ROR before the
Also, there are
there must be a
is constructing over 2 lands. One encroaching and another the forest land has been provided.
they must be making a construction on the base after they obtain the sanction building plan from the competent authority.
Nothing.
Not yet. Then how construction is done without the sanction? Is it mandatory here?
My lord, may I permit me to take instructions in this, my lord, because my lord, it's come for the first time, my lord. Because I am not.
I am asking you the law.
My lord, please.
I am aware of some other law where it says that nobody would be permitted to raise any construction without the sanction being obtained from the competent authority. So that is, we call it a sanction building plan.
Yes.
Is it any provision? Is there any law? Is there any statute which mandates such thing? Should be.
My lord, there is a, my lord.
There cannot be unregulated
My lord,
the construction of the building. There must be some regulation.
my lord, there's a Development Authorities Act is there, my lord. Urban areas. For urban areas, my lord. Under that, the CDA, my lord, the Development Authority, they grant permission and regulate the construction.
What about the urban area?
Urban areas, my lord, under the Gram Panchayat Act, my lord, provisions.
Correct. So there must be a provision that they must seek a permission, they must sanction it.
My lord.
They are also under the Panchayat Act, there is a provision for sanction of the plan.
My lord. The provision is there, my lord,
But
but
have you issued a plan?
So, status you have given to the name of the person. Status, name of the person.
my lord.
So you have recorded in his name by way of a case,
My lord.
Dakhal Kharij. But what is the remark here? Column number 6. Jungle Vivadara Procedural Niyamanujai discusses notes of জঙ্গলে জাতীয় দ্রব্য ব্যবহার করুন welfare you settle the jungle land forest land
Well, that is-
discover. I do not verify whether this is sort of error is generated on the purpose of giving rights of the aborigines or tribal people under that tribal act. Act is the middle forest or in the forest area. They reside and they use the forest produce.
Yes, my lordship, that is the father age
Are you
34.
aware of that? Land settlement.
No, that is the father first. That's he inherited. Then my lordship age 36. Again another plot has
Have
been
you
made.
seen that act? Have you gone through that?
Raman.
Have you examined that fact?
Right,
What
so
is that?
forest
Right
dweller,
of forest
forest dweller.
dwellers.
Yes. Is it-
In 2006, I think.
And the cutoff date will.
When you are drafting a public interest litigation, are you not aware that there is also any scheme floated by the NASA, the Apex, the legal aid body under the legal aid authorities act?
Lordship, here the OP4
Which
is
is
the
called a
government servant.
Sambar, which is called a Sambar, which takes care of these tribal.
No, he is the government
their
servant.
rights, the rights to remain in the jungle, rights to remain,
My lordship,
Uh,
the OP4
to
is the
utilize
government.
their resources.
Government OP4 is the government servant. There's no link with the government. First land.
The tribal cannot come in a government,
No, he is not the tribal.
in a government service, according to you. That means
No, he is not the
you are
tribal.
making a distinction between a tribal and the government service. So
No,
the
no.
tribal is not entitled
No, he
to
is not the tribal.
occupy any position in the government service.
No, he is from the tribal people.
The otherwise you are an ex, have you not read that month of book as we call it a month of remarks? What is said there? What is said here?
It is Mantavya column.
It's the same word.
Same.
Have you not read the month of book?
Yes.
What it says?
Granting this reason for granting especially at problem number 6, which shows that जंगल विभाग ର ପ୍ରଚଳିତ ନିୟମ ଅନୁଯାୟୀ ନିଷ୍କର୍ଷ ଦଉଥିବା ବ୍ୟକ୍ତି ଜଙ୍ଗଲଜାତ ଦ୍ରବ୍ୟ ବ୍ୟବହାର କରନ୍ତି.
That means he is a tribal. His forefathers and all, everybody, they are aboriginal.
No, man. Because the page 34, his father's name, and he
I am
inherited
not
the
saying
property.
about tribe. I am not saying about tribes. Tribal means dwellers in the forest.
No, he has property. Inherited the
He-
property from
perhaps-
the father.
Perhaps you are in the mind that I am telling about tribes. I am not telling about tribes. In the 2006 and there is a
Go through. But he has no link with the jungle, forest, anything. But he has been giving while he was in
No,
service.
then what is this? ଜଙ୍ଗଲ ବିଭାଗର ପ୍ରଚଳିତ
That's a-
ନିୟମାନୁଯାୟୀ. What is that?
That's I'm saying. Because
Oh, what is that?
on this
So
ground, he
if
has-
there is any wrong recording in the recorder, there is a provision, somebody can go before the authority and claim the correction thereof. Can a writ petition directly lies?
So that since with the villagers, we are coming here.
We villagers, then order one good date representative capacity, then you seek for first the leave of the court, he can't give you. You are coming in a representative capacity, we will not pass any interim order.
And another plot, my lord, is
Maybe it is like a representative capacity suit or a class action, then you'll have to justify. Why not leave under order one, rule eight be sought? Without the leave, it is a stillborn proceeding. There's a division bench judgment of the Calcutta High Court, Devkin and Bumna versus Calcutta Supreme Court. Unless the leave on the order on the due date is sought, the suit or the proceeding is still born. If it is not born, then no interim order, no order can be passed there.
No, I'm not paying for any interim order.
Any order.
Yes, I'm paying, so let the direction to consider my
Can
demands,
be-
Lord.
Can be in a stillborn, is in a stillborn proceeding. It is not born.
Take instruction, my lord, with regard to encroachment proceeding, my lord, they have not initiated.
You go before the authorities and whatever you want, just say the wrong recording, wrong entry or erroneous entry in the record of right. You go and challenge it. Make a proceedings. I do not know.
We are before
If there is any limitation for
direction to consider.
What is the, what?
We are before the authorities under Annexure 1, that
Yes.
is direction to consider it.
Chosen a wrong bench and a wrong person. I have a strongest of reservation on disposal of the matter to consider representation.
So that's why I'm, I'll.
Show me your right.
No,
I will decide. If I do not find any right,
At the
I will
very beginning, I was not saying
Straight away.
that my, I know my lord.
No, I think the resurrection of the steel claim or a dead claim by virtue of giving a direction to consider it. You know,
Let them take instruction, my lord, whether initiated any
No,
proceeding or not. Not the construction is going on.
but there is a, it appears that they have been settled in that. Land Reforms Act there, that if there is any wrong, erroneous entry in the record of right, then there is a competent authority, the revenue officer, who can initiate a proceeding on an application or may also initiate the review suo moto and the different period of limitation provided for that. What is the law here?
Well, it's here, he'll have to file a mutation appeal because this order is passed by the Tahsildar before the sub-collector.
It's not a question of mutation, it's a question of erroneous
Record of.
entry in the record.
Record of.
Is there no provision?
And
So,
the
much revision
suo moto revision.
Has to be,
is there, sir.
which act?
That's authority over the 70 years of over. That
No.
are there no so much revision power? Yes, sir.
Has to be there, no. Has to be.
Every act
Has to be there, no.
has to be.
Other service the customer district under under copy and the GLS of.
Yes. But I'll have to check on that, my lord,
I
because
do not know what is the modalities in this state, how the things are dealt with, as so far as the land is concerned. Mr. Parija, you must be appearing for the state. What is this? Because I have come from a state where from originating from Bengal till NCR, and then after there was some kind of a reform which was done. Then the West Bengal State Acquisition Act 1953 was introduced. And the cadastral settlement that we call as CS.
yes, sir.
And that was undertaken there. And then by virtue of these act, then the revised settlement that came, RS.
We have a Service Settlement Act.
Yes, CS, RS, and now it has, after the land reform, it has gone to LR. So there are three modes of recording the entry in the record of right.
But there is a provision called Section 34 in the Orissa Service Settlement Act.
Yes. Now, was there any settlement done when there was a movement?
But there is a power to suo moto correct also.
So much power, sir. Revision power always existing.
এটা দেবো না।
Regular revision.
No, was there any trial for settlement?
Tahsildar. If the power
There
to
must have been.
so more to correct
There
the
must have been.
entry.
Because there were three trials for
relationship
settlement.
with the existing.
One in 1902 or 3, that was the cadastral settlement at that point of time.
land.
The survey settlement.
Then there was a revised settlement.
This is under survey settlement.
Okay.
Opinion act is also there. Under that also.
Eviction point. That is for eviction though.
No, I was just thinking. because-
I understand what your lordships are saying.
At one point of time, when they wanted to create a report, there was a drive, it was.
Mr. Samar knows all these matters.
And there was a drive which was in Bengal region. In Bengal, I'm just asking, there was a drive during that era when they wanted to create a record and just keep all the land records with them. So then they started moving place to a place in the villages. And that was a very unmethodical way of
Recording rights.
They used to go in a house, how many lands you have? They used to say this much of land is there, just a peripheral and record his name. Then the same thing was done when they wanted to revise it in 1953. We used to call it a Gujarat or something like that. These proceedings were there, the Samiana or the tent was fixed in the village and inviting all the villagers to come and just record your name, how many land you have. So this is how the land records were prepared and the ROR came into effect. Then there is a provision that if anybody has any objection, it so happened that one person's land is recorded in the name of another person. After knowing that, then this person comes and claims on the basis of a document, the practice document, that this is my property, how can it be recorded? So there are two modes of correction. One is on an application,
No,
or
there's so much.
suo motu power of the authority to revise. On an information. What is the modalities?
But section 34 of the Service Settlement Act, it says either on the own motion or on somebody's application.
Yes.
Grounds on
Same,
which
but
correction of
has to
ROR and map is to be made.
Yes.
Lordship may see section 34 minutes. My lordship 34.
Section 34 of
The
survey and settlement of what?
rules, survey settlement rules, Lord, 1962. I'm sorry.
That is the power.
Yes.
I think it must emanate from the statutory,
Yes.
the act itself. And there is no limitation which is provided here.
15B is the provision under the section. Section 15B of the Service Settlement Act. That is regarding revision of the record of rights.
If only a consular so much of.
So far. There is a limitation.
1 year from the date of the final
Final
publication.
publication.
And suo motu?
That has been interpreted by various judgments, and that 1 year has been waived now. Now people are filing cases even after 10 years, 15 years. There is a link in section 15 be read with 34. The petition shall be filed thereafter. The division bench judgment is there. Even if the revision filed after 30 years, it has been entertained and direction has been issued for correction of the record of right. And to your lordship's query, previously there were some settlement officers report. In respect of the postal, there was madam
15B is very unhappily drafted.
like the what thereafter.
Yes, creates a confusion.
Thereafter 1 year for filing of the suit.
Because there, the 1 year or 2 years on the basis of an application which is given on the date of the final publication, of any application. And 60 years have been given suo motu power.
Oh,
Yes.
I think in 2020 or 21.
Perhaps
There is an amendment introduced with regard to this limitation. Where is it challenge?
1 year has not been changed. But it has
You go before the authority, you make an application if there is anything. You can store a judge. Put it in this way. This can't. Anyhow. It cannot be done. Please.
7.
May I clear?
Yes.
The notification at page 22 under Annex 3 is under challenge before your lordship. This is regarding reconstitution of the Board of Trustees of the trust called the District General Foundation for the District Diocese.
The statutory trust.
Statutory trust. Statute provides Rule 4 BI. I have quoted and I have extra copies for your lordship.
What it provides?
It provides that not exceeding 3 members of the Panchayat Raj institution or urban local bodies from the area in which the major mineral concession is situated to be nominated by the government as members.
So outer cap is 3.
3. My lord, in 2017, they have elected 3 from that area where the major mineral are situated.
Correct.
In 22, they have done the very same thing.
Correct.
But in now, they have nominated some 4 persons
Where?
who are at page 22,
Yes, I'm looking.
clause XIV, XB, XBI, and XB2I. They are not the person belonging to that.
I could not get it at page 22. Which one?
Annex
There
of
are-
3
there are 17 persons.
My lord, 17 persons.
Correct. Tell me. Panchayat is only 3.
Okay, Panchayat only 3.
Correct.
My lord, they have selected XIV. Your lordship may kindly have a class. XIV.
ID
14.
IV. 14.
14.
14.
Say that.
14, 15, 16, 17. These 4 persons do not belong to that area. When the statute provides,
I am not very accustomed with XV or XIV. Actually,
sorry, it is
I'm
written.
concerned with Roman 4, 14, Roman 15. So that's why.
Sorry.
So I was not getting it. So he's as a Jilla Commission member.
Of zone number 39, which is beyond the area. I will take your lordship to the previous page.
No.
All these mining activities are continuing.
Oh, that is a different issues. Ex officio members, whether the rule provides that one person from a Jilla Parishad will be a member.
My lord, only things provides a member of the Jilla Parishad situated within the district wherein the area in which the major mineral concession is situated.
According to you, zone number 35, outside.
I is outside.
I will take instruction.
Okay. 1 week after. That's the only thing. Let them take it.
The operation of the.
What of? They are simply constituted. What's wrong?
Every number law.
Have you filed your application?
I have also filed my application.
What is that application?
That application will also categorically states
No, which application?
application number.
Flag B. Flag B. Flag B.
My lord, item 9.
I
Let's on behalf of Mr. Kanungo, my lord, that refer as one password.
14958. IA.
14958.
Yes,
Flag A.
My lord, item
That is
Item 9.
4621.
My lords, this is that work, my lords, where this government had invited tender. That's Mr. Kanungo.
My lord, sir, here, I'm sorry, my lord, sir. This is a tender, the Contractors Association. Association has filed this written application before your lordships. Now, a tender has been floated for mastiff work. That is a type of pavement, my lords. Concrete pavement, bitumen concrete pavement for making the roads, my lords. Now, a specific stipulation in the contract was at page 27.
What is your right as an intervener?
My lord,
The intervener, my lords, in a welfare state under Article 38, my lordship should be very constrained not to invite relating to a tender for the simple reason which the Supreme Court has categorically stated, my lords.
I'm more concerned with your right in
My right,
respect of
yes.
the relief
Well,
claim, whether you are a
because
necessary party or a proper party.
Yes, I'm a necessary party. Why? For the simple reason, I fulfill the conditions of tender.
Okay.
If I fulfill the conditions of tender, and it can, and the state government has the prerogative to.
Have you participated in the tender?
I have participated in that. Participated in, I have applied, only applied for the tender.
Yes.
But tender has not been awarded to anyone.
Okay.
I'm only a participant.
Okay.
My lord, this is exactly what
This is
we are
this-
challenging.
yeah.
This is, if your lordships can, my lords, I have no objection in his intervention, my lords.
So let that be allowed.
Yes, my lords, let the intervention be allowed. My case is very simple, my lords. He does, my lords, if your lordship kindly sees page 27, your lordships will just take up page 27, clause 11, serial number 11. Lordship gets it. Tools and plants and machineries, as per the requirement in Schedule C, minimum 80% marks to be obtained. Proof of ownership of tools and plants and machineries are to be furnished in shape of copies of invoices, required sales deed in case of second purchase, prepared lease deed with other documents of the lessor duly attested. Distance from site to plant should be 30 to 40 kilometers. Now, none of the contractors in Orissa as well as outside have any plant within 30 to 40 kilometers within the work site, that is Bhubaneswar. And my lords, they are now giving undertakings that if I get the work, my lords, my associate will hand over this declaration to your lordship. This is their undertaking that if I get the work, I will make a plant, I will establish a plant within 40 kilometers of the work site. Now, my lords, your lordship is aware once within 45 days, once the work has started, once the tender has been floated, the game has started. You cannot change the rules of the game. If such a clause would have been made available, then all of us would have participated. We also would have given undertakings. Your lordship may call for the entire file. They are giving undertakings. And because of that, they have technically qualified them. Lordships will see the declaration.
My lordship would see paragraph 5 in response to what.
Your lordships will first see the declaration. Right? First paragraph itself, that if the contract is awarded to me, I will deploy at the site all necessary TNP and equipment as per requirement for execution of work within 45 days on
Sir,
receipt of the work order.
with deepest respect and humility. Now, question is the participation. If somebody participates, it is the authority who has to take a call and will decide whether they fulfill all the eligibility criteria or not.
Yes, sir.
Participation does not really vest any right into the participants to have the contract. You are just presuming that they will dispense with this particular rigor of the clause. They have not taken any decision. They have not taken any decision. Let them take a decision at this stage. Why we will interfere?
My lords, my client has already informed me.
It is not that the authorities have diluted this particular clause. Now these people who are the participants have submitted this.
Yes, my lord.
If they have submitted this, the authority has to take a conscious decision thereupon. Whether they will accept or they will not accept. If they accept, definitely then you have some cause of action to come.
My lords, they have technically qualified them. That is my instruction.
Where is the, no sir, you have not pleaded something, you cannot come at the bar.
Yesterday,
Where you have pleaded that they have already qualified everybody in the technical bit.
Yesterday, they have I give it by way of an additional affidavit.
Then file your additional affidavit, we will not permit any improvement of the case made at the bar. Unless there is a specific pleading and the evidence.
I have on instructions, I am apprising your lordship.
No, sir.
That yesterday they have
Instruction will not
technically
do.
qualified them.
When they have been qualified?
Yesterday.
This,
Your lordships may ask the government.
no.
We will
When they qualified yesterday, if in violation of this clause.
nothing you bring on record, we'll
certainly have to
consider.
call
Yes,
an
this
action,
is,
my lord.
this is an application at the behest of the intending participant. Not listed when we lost on Friday. I do not know. I have given a leave. If they file an affidavit, leave is granted to mention the matter. So accordingly disposed of. Not your application is disposed of. Intervention was disposed of.
Item 10.
The public interest,
For eviction.
not for eviction, but here, the opposite party number 8 and 9, they have improved.
So your prayer is for eviction of unauthorized encroachment. That is what I am asking.
They have,
Is a regular feature here.
they have improved upon a land which has been earmarked for public park.
What do you say?
Minor kind of annexure 8 minor kind of. And on the basis of complaints lodged by the petitioner, the steps were taken by the authorized person for eviction. But since police did not cooperate, so eviction
What?
could not be carried out.
Why the police is not cooperating? The authority?
And the proper authority is the Contempt Development Authority.
Proper authority is a police personnel.
Annexure 8 has been.
Tell me. Forget about CDA, forget about everything. The letter has been written by the encroachment officer
That is the
that please provide me an adequate police personnel. And you are not providing an adequate police personnel for eviction drive. Why?
It is inside the Kotak town.
I will take instruction because this is a communication made by the Contempt Development Authority with the petitioner.
Whatever.
Come to page 38.
Yes, Miraj, I am happy.
So
So there is
who
a
will
company.
provide?
Who will provide?
Yes, I will take.
Why have you not complied this request?
This is the
No,
request.
this is what is, he says that it is communicated to him. I understand. I am not on that home communication. We must have gone to the police personnel and the police personnel, they are not providing an adequate number.
If it is so, I am taking instruction.
When the copy of the writ petition was served on you,
For
today is, what is expected to be done when a copy has gone? Will you not immediately contact after reading the content of the writ petition and then ask? It's a very routine and a regular feature which I am saying that it is the first time appearing. Let me take instruction, even if the copy is served 3 months before. So you just waited for the matter to be listed. You will not take any instruction. Is this way
It's not.
the functioning of the court is perceived?
No.
So
In other matters, we are ready with the instructions. But
whatever, but why not in this matter? It's a serious matter. And a statutory authority is raising an issue on the police administration.
Page 33 is also very good.
That's my take up this matter tomorrow. Today I will take it.
Page 33. Have you read that?
You don't give, we are directing the central police force to be deployed. Don't. You don't have the adequate numbers of the police personnel. You can't maintain the public law and order, though it is a state subject. You are unable to comply. So we are deploying the central.
We'll take instruction. So may take up this matter tomorrow.
Yes. Tomorrow.
Item 11.
Will not meet the alert. I was granted a mining lease, personal and option. And the area that was allotted to me is about 63 hectares. 74 hectares, I'm sorry. So very lordship, when I get a mining lease, I have a legitimate expectation, the right to mine over the whole area. Area within the lease. Within the leasehold area. And Milord, over an area of 14 hectares, there was, which is 19% of the lease, it is almost 1/5. There were old stocks lying of the erstwhile lessee. There was somebody who left the lease was put to auction, and then I come in. So, and my lords, beneath that 14 hectares, there was a large amount of reserves. So what I do is, I tell the government that, look here, either you remove it or you allow me to remove it so that I will have access to the minerals. And my lord, this went on for a long time. And one of my first letters in this regard was on 14th of February 2020. Kindly note that 14th of February 2020. I have a list of dates, I will come there. Now, what they do is, they do not respond. Because
Today also,
they don't respond.
today also. Take instruction.
But something more has happened.
No. I'm asking whether the same,
Yes.
they take instruction or what? Yes. Yes,
I've taken.
yes. I expect it.
What happened thereafter is, when they don't respond to me, then I invoke the force majeure clause. Under the rules, Rule 12(1) FF of the MCR 1960, as well as the MDP agreement, there is a provision that if the situation alters the very foundation upon which the MDPA is made, then force majeure applies. So I said, and there is a rule which says under Rule 16 that if I make such an application, then they have to come, they have to call me, we'll sit and discuss what is the way out. That representation was also made, Lords. Annexure 1, page 52. My Lords are kindly pleased to see. That was made on 19th of April 2025. And there were reminders thereafter. There are as many as 4 reminders thereafter, the last of being on 1st of August 2025. Still no reply. Would you Lordship just see clause 16 of the MDPA for a minute? If you Lordship don't mind. Annexure 3, page 117. 16.1, Lords, event of force majeure. I'm sorry.
Yes.
And my lords, kindly turn to page 119.
Yes.
See clause 16.3. Upon occurrence of an event of force majeure, the successful bidder shall, as soon as reasonably practicable, after the start of the event of force majeure, but not later than 30 days from its start, notify the state government in writing of the event of force majeure, the date on which it has started, or is likely or potential duration to that effect of the force majeure, and its inability to perform any of the obligations under this agreement. Use all reasonable endeavors to mitigate the event of force majeure and performance of its obligations, including following of good industrial practice. Now kindly see 16.4. If an obligation is suspended by reason of event of force majeure for more than 1 month continuously, parties, this is the grievance, parties shall enter into good faith negotiations to revise the terms of the agreement to reflect the changed circumstances, provided that this agreement shall...
What are the force measure defined?
Yes,
in
kindly see, my lords, under this agreement, the Lordship
16.1.
16.1.
Please show me which clause.
Now I am relying on 12.1 FF. And why 12.1 FF?
Because if they have specified the force measure events, then can you go? Because it is neither, I do not know, even six does not come in the way.
Okay, none of them come. Let me upfront tell you, Lordship. Now kindly see page 83.
What?
Page 83.
Yes, what?
Of this MDP agreement, my lord.
Yes, what it says.
My lord, it says Act means the MMDR Act 1957.
Yes.
Now kindly see applicable law 1.14.
Correct.
Applicable law shall mean all applicable statutes, laws, bylaws, rules, regulations, orders.
No difficulty. It has to be.
Etc. So now kindly see, my lords. Page 87. 1.128.
What it says.
So it says MCR rules will also apply.
No difficulty.
So, my lord, my submission, 12.1 FF, if your lordships kindly see, under the law. This is mineral concession rules. Rule 12(1) effect. Mineral concession rules 2016.
Yes.
Page 394, my lord, your lordships are holding professionals.
Yes.
Failure on the part of the lessee to fulfill any of the terms and conditions of the acts and rules made thereunder. The mining lease conditions made thereunder. The mining lease shall not give the mining lessee. Lord, may I read it again? Failure on the part of the lessee to fulfill any of the terms and conditions of the act and rules made thereunder, or under the mining lease, shall not give central government or state government any claim against the lessee.
So it says that if any force majeure comes,
yes.
If it does not come within the force majeure,
yes,
whether you can take advantage. Where is that?
Proviso. If you don't mind, not just
force majeure means an act of God, war, insurrections, riot, civil commotion, strike, earthquake, tide, storm, tidal wave, flood, lightning, etc. Any other happening which
the lessee could not reasonably prevent or control. I am come under this, and I'll tell you what is why. Because once you do not allow me to mine the whole area,
this is the happening which the lessee could not reasonably prevent.
Correct. My lord, what happened? Prevent, I could not. Because
could not prevent.
Yes, my lord, the submission is this. You give me a lease, 1/5 of that lease has dumps of the previous lessee.
I understood what you are saying. I am just trying to figure out the meaning therefrom.
Yes,
could not prevent or control.
Because this mining operation.
What is the prevent? What you can prevent and what you do not have a control.
What I do not have control is that in my lease area, there is.
Is it not referable to the earlier incidences?
This is in addition to whatever is said in clause 16.3, because the act and the rules have to be read into this agreement. That is what the agreement says. The MDP agreement says that the act and the rules shall apply to this agreement.
No, I am conscious about it.
Yes.
If there is no particular paraphrasing of a particular event within the force majeure clause, I understand. If those can be seen from the statutory rules or the statute, then those are deemed to have been incorporated in the contract. I have no confusion, no ambiguity in my mind, sir.
Correct.
Only thing is that when it talks about
when it talks about 1 to 5,
other happening,
yes,
other happening means what? A happening of a like nature.
Yes, my lords.
Which could not be conceived because every happening
1 to 6 are all happenings which are beyond the control of the lessee.
No doubt about it.
Now, what has been, my lords, the act.
When it talks about other happening means other happening which are not incorporated in that particular expression or the clarificatory clause.
My lord, what I am saying is, Lord, 12.1 FF, which is in the rules of 2016, will be read into 16.
Oh, no doubt, sir.
Yes.
I'm just trying to figure out the meaning of any other happening.
Yes.
So what it conveys, any other happening which is there in explanatory clause.
Happening.
What is meant by that? Happening means definitely, logically, it conveys that what is not expressly indicated in the earlier portion of the explanatory clause, there may be some other happening.
Yes.
If that is correct, which is to be, then that happening must have some relation or nexus to those.
Yes. Now let us see what is happening here, which I am complaining.
You are saying that there was already a stock stacked at a portion of the property which is the part of the lease deed. Since the minerals are still lying beneath that particular stock, so you are saying that you are prevented from extracting those minerals.
Yes.
And therefore, why not the force majeure clause will operate? I understood. But I was thinking in a different way of interpreting the provision.
Yeah, I'm grateful. So what I do is, why I do, to mitigate that hardship, I write to them for the last 1 year or more that is either you remove or allow me to remove. And I gave 11 letters. If they would have removed or they would have allowed me to remove, I would have had access to that door.
Now, what is your grievance? That they have imposed something, demanded something.
I said under 16 point.
No demand is made.
No, one
Only
second.
appearance.
Anyway, let us see annexure 1.
What is your instruction?
Yes, sir.
Now you received. Then I must compliment you that at least you have received.
Two documents that I have. And in fact, the annexure 1, so far the annexure 1 is concerned, Miller. One reply is already sent to them. Let that separate question.
Each one is But they have already responded. They have acted upon your letter. And they have indicated everything to you that what has happened. There is some kind of a, I could visualize an impasse having been created.
Yes, sir.
He says that there was already a physical survey of the spot on 26/6/2024 to ascertain that how much is the minerals or the materials which are dumped earlier.
Yes, ma'am.
And they have also handed over to one company
Yes, ma'am.
to lift it immediately.
But is that
But by virtue of an e-auction. But thereafter, they are saying their inability that after that particular auction was held and the particular company is declared as successful bidder, he is not responding nor lifting.
But my problem is
Very. That is what I say that goes in your favor. That's why something which. So now, that's why I say thou use the word impasse.
So
what he will do? What he will do? I appreciate that you have immediately acted upon their request. They have taken a plea, which I was also thinking that this event does not come within the force majeure clause. They are very categorical.
This letter is not served upon us. This letter is not served to us.
No, that's all right. We will get that letter. Naveen. That's not the point.
Who is he?
Mr. Naveen Kumar is assistant. My submission is this. You admit
May not, because it is for the first time it is served.
Yes. My submission is this. Now, admittedly from this letter, that dump is still lying.
No, they are admitting. No difficulty.
The dump is lying. How will I mind?
It's true. Now, question is, the only thing is your apprehension is that you have been given a target or a particular time.
I'm grateful.
The quantity has to be extracted and does it.
Yeah.
Now you cannot meet those, then they can take an action against you for breach of any conditions of the deed, meaning these deeds. But they have said that they have not taken any steps as yet.
I'm grateful.
But they have been very categorical that yes, I realize these are the problems. we have taken a steps for removal, but the another company is not taking any. Then how long will it go continue? How long? How long they will continue to suffer? Then for this particular period, they should not be saddled with any kind of a. Is your lapses.
To that effect, no demand is issued till now.
True. So we'll record that.
Yes.
We'll record this.
That will suffice.
I received this instruction just now. Let me file an affidavit to that.
What affidavit?
Counter affidavit.
Very clearly you have said, yes, we appreciate that. First thing is you have said that you have raised the issue of force majeure. That does not come within the purview of force majeure. Very, very interesting. No difficulty. Secondly, in the last paragraph, you have said that yes, there was an inspection which was done to assess what is the quantity. You have already done the e-auction. You have chosen a particular the bidder. You have directed them to lift. He's not lifting. He's not responding to your letters. Where is their fault? Once you have acted on the basis of their letter, means you have realized the genuine difficulties which they are facing. Otherwise, you could not have gone for a e-auction. And the second thing which appears that they cannot deal with those particular the stuff. They cannot deal with because you have taken a charge. Now you are a custodian. You have a right to dispose of. Then what they will do? That's very clear from this letter. That is what is the letter that comes.
Let me file an affidavit.
What for? We are taking this on record. What more?
Clarifying that position.
What clarifying? It's your letter, sir. It is your letter. And I think somebody has made a mark with the red ink.
That you have read appropriately.
And my lord, there is one more letter that you don't go within 100 meters circumference of that area by the DGMs because they said one say. That letter, your lordship will see at page 66. Director General Mine Safety. He says you can't go within 100 meters of that dump.
What is this OMC Limited?
That is Odisha Mining Corporation.
So it's really a left hand and a right hand.
But actually, they are represented by mother lawyers.
There is no grievance here against them because they are not aware that what you have done.
Whether they have access to that or not.
Sorry, they have an access or what? Have they come forward and give you a reply that I wanted to lift it, but they are denying any access?
That instruction I not have.
Nothing. No. Because the moment I put a question, then again you will say.
So far this
But you have not been able to show any correspondence from OMC. All the correspondence is from your end.
I will take that instruction.
No instruction.
Not having the sufficient all the details. Only this details.
Not this.
I have seen the nature of the interim order.
Yes.
Is merely on apprehension.
No, my lord, what will happen?
It is not. We will record his submission.
Yes, great,
Record his.
great.
Uh,
Well, I have one submission that in pair number D and E, pair number D and E, they are declaring the ultra virus of the 12A. 12A2 of the NCR 2016, which may be segregated this if they are on the repetition and the state will taken steps. There is no question of raising the point of causing ultra virus of the 12A. There is no issue at all in this regard. Spare may be ignored.
It is a central legislation.
Yes.
So
Yes.
they are challenging it. You are notice. You are notice.
Notice there is no
So they
issue
will
because
now for the purpose of an interim order at this stage, because we have to invite for the purpose of interim order that appears to be an apprehension on their part. So this apprehension he has taken care of, saying that nothing has happened.
that part is also in the part of the state government, and central government has no rule to pay.
Whatever
Whether
is
it
there.
has already been taken care of by the central government.
Have you given a notice to DSG?
Think topic is first before this.
Like apart from a writ of mandamus against the
Yes, Item 26, the personal offense SP judge code regarding the rescue of the minor girl of the petitioner. The girl has been rescued and she has been brought from Delhi. SP and IAC, they have come and present at 2 o'clock.
Emergency in this matter, and the Supreme Court was pleased to say that today it will be heard.
Let us see, sir, we have enough time now.
Sir,
Let us see. Yes, madam.
26.
Yes, yes, yes.
item 26. I complain.
12.
I complain. The petitioner has been blacklisted. Right, Annexure 7, page number 71, man. The blacklisting now.
Yes.
Solely on the ground that I have not accepted the LOI on a price that was not quoted by me in the price bid. While participating in the tender, I had put my price bid is at my page number 67, Annexure 4.
Where is the ground which they have said that you have not quoted?
Page number 71.
No, it says that refusal to accept the award of the contract.
Man, when you have refused their LOI,
Where they have said?
the paragraph 3, page number 71, Annexure 7.
I am looking at Annexure 7. Which paragraph you just show me, which line?
Paragraph 3, however, it is to be categorically stated. My lord,
Yes, LOI was issued.
strictly in accordance with the rates quoted by your firm in your finance.
Correct. So that is the rate quoted.
No, man, that is not the rate quoted.
What?
Also, I have annexed my price bid, my lord. My price bid is at Annexure 4, my lord. My lord has.
Yes.
In that box, my lord, second column, fixed price for plate for 201 to 400 number of students INR. That's
What?
in that box, my lord, second column, price. This was a tender for providing catering services, my lord.
Yes.
My price bid stated that if the number of students
29, 46, 17 and 40. Then?
no, 28, 44, 17, 30. This is relevant, my lord. Because
No, this is the first column is fixed price up to 1 to 200 numbers.
200 students.
Correct.
Here students are more than 200, so therefore second column is still on.
Yes.
Fixed price for 201 to 400 number of students, 28, 44, 17, 38. Total is 127 rupees. Thereafter, my lord, I was declared L1 and LOI was issued to me. However, in the LOI, they provided that there are total 280 students. So the second column that between 201 to 400 that will come. My price for 201 to 400 students was 127 rupees. The LOI is issued to me. 120 rupees. The LOI is issued to me to take up the work at 127 rupees. It was 7 rupees more than my quoted price. So LOI is at my page number 68, Annexure 5.
So what is wrong in it? You are giving you are getting more.
No, I have quoted 120. I have quoted 127.
And it is given. You just said reverse. That I was really shocked that you have quoted 120. You are awarded a contract at 127. You should be happy.
No, I had quoted 127 rupees. I was asked to the LOI to take up the work at 121.
Okay. Say that. That's just the reverse.
I'm sorry. 120. since I was declared L1, I have submitted my price bid, and after being declared L1, the LOI was issued to me. Since I was asked to take up the what at 7 rupees less, I made them a reply memo.
Where is the LOI?
LOI is at Annex 5, page number 68. The box contains the total number of students 280. Adjacent to the in the adjacent column 24, 42, 18, 36.
Yes, then
Total is 121. Thereafter, my lord, I replied to the LOI. My reply is at Annex 6 panel, page number 70. That it is typography.
you have quoted 137, sir.
127, that is a typography.
Not 127.
It is
And
1.
then you say 17.
And
That's
it's a typography error in the representation. It is 127. I quoted 127. They asked me to take up at 120. Therefore,
so what?
So I replied them. I refused to take the LOI at that rate.
Where is the other side? How can it be? If he has quoted, then how can you award a contract at the lesser price?
And actually, this order include this past by World Skill Center notice is to issue to them. Opposite party number.
What is this? World Skill Center?
It is a government of Orissa company. That is in their tender advertisement.
Issue notice. Notice come back immediately after vacation.
And even meantime, they have blacklisted me, and also even another disproportionate order, my lord, that they have initiated communication with the MSME department to cancel my.
We will consider it. Don't worry.
Well, however, in the meantime, and participating in other tenders, and this blacklisting order is there.
Where you have stated that you are participating in other tenders in this period.
And right now, I have the work order.
That you will continue.
But my participation in the further tenders
I am asked you, tell me that when other tenders are going to be floated within that particular period, I am directing this matter to be listed on 8th. You show us that there is another tender which is floated, we have to participate. I will definitely see.
And there are other tenders I have not.
So then come on 8th. Come on.
Item 13.
Remember, the notice of forfeiture of a property. That is under the next of June. But remind that property I have acquired. It involved in the offense under Narcotic Drugs and Psychotropic Substances Act. That notice has been issued. Loss will come to page 23. Under section 63H.
This order is passed by the Calcutta?
Yes.
So?
There is no appellate authority. There is no competent authority.
So this letter says that you will have to come before the jurisdictional competent authority within 30 days.
No, that
is the notice.
My humble submission, Lordship, is the entire proceeding, right from the issuance of Annex 1 and 2, that is without jurisdiction. And because this is without jurisdiction, that's the reason why I have come up before Lordship. Because Lordship kindly peruse the very section.
Where is the provision? Then is a criminal the repetition.
In DPS, of course, because
definitely, then it's a criminal repetition.
But you know, the question of law is involved here.
That is not. Because there are judgments of the Supreme Court, whether it will lie before the division bench.
The issue involved, you must can come to that section.
What is that? I'm giving you a judgment.
The complete question of law is involved, that the reason was probably
it does not.
The residual matters it has covered for last
Ramkishan Fauji's case. Ramkishan Fauji's case. Of the Supreme Court.
It is regarding
Is it relating to an appeal against the writ order? Before the inter-court appeal, whether the appeal would lie when the court exercises the criminal jurisdiction in the writ.
But is it the criminal jurisdiction that is also?
That is what is, because it is emanating, the action is emanating under the Narcotic and Drugs Act.
Here regarding the public of property, yes, there was
Whatever, the power is given under the act, then you'll have to go there. Suppose in the Indian Penal Code, there is a power to confiscate the property. If the confiscation is done, then you say it's a property. So the civil writ will come. Intricate question of law is involved. It will be there. It has to go to the single bench. We don't think so. Have you got that Ramkishan Fauji? Yes. Which one?
Yeah, 2017.
You have got that?
India community.
Yeah, 2017.
17 SC 1535.
No, Ramkishan Fauji.
What's the state of Hawaii?
That is 2075 SC 533.
That is what I think.
Yes, that is. Yeah. Yeah,
You go through it, I don't think so that there is, it will lie. Sorry. It will not lie for us.
Tomorrow I will take it to the.
Just to go to the city. So let that judgment come. We are fitting this tomorrow. And we can give a judgment.
Take it to us.
Item 14.
My lord is adjourning the matter, item 13.
Yes.
Item 13, adjournment.
Not what we are thinking, whether the single bench, it's a single bench matter or a division bench matter.
Okay.
10 or 14.
But the IOCL and FPCL motion. That IOCL and FPCL matter.
Oh, that is what, sorry, I'm in the midst of a dictation. It will be completed today. Tomorrow.
There is serious discussion on the
I understand. You are a person who subsequently participated, one of the partner.
Right.
Understood.
My partner was.
All the facts are known to me.
So the thing will also dictate the judgment in that IOCL matter, consequences to follow in this.
Yes, if I do not find time in the evening today, then I will list that matter tomorrow for dictation. In the open court, I will dictate.
So great. Great.
Yes.
Item 15.
15 may I think. There is a case now, which is not disputed that the petitioner's land, sand and moram have been seized by the authorities and while he was stored at a place lot. here on the last occasion, your lordship has called for a instruction, but lordship will take your lordships to the minor minerals concession rules, section 54, your lordship. My case is very simple, your lordships, that without adhering to the procedure prescribed under the Act, the entire procedure, the entire seizure has been done without giving any opportunity of hearing. Now he has proceeded to, my lord, confiscate as well as for going for auction.
Where is the provision
Section 54, your lordships,
of the Act?
of the Odisha Minor Minerals Concession Rules 2016.
Rules does not have a section. Which rule?
Rule 54. your lordship. Beg your pardon. May I please?
Yes. So what is this? The search is there.
As per the procedure of criminal procedure, he has to serve, my lord, the seizure list has to be given. Here in this case, your lordship may see the annexure, they are annexed, your lordship, page number 24, page number 16. Straight away, the liability has been fixed. Now, my lord, of the said material, I have been given notice that I have to deposit, my lord, 21 lakhs, but he has put fixed the date of option for the next date tomorrow for the rupees, my lord, 2 lakhs some odd rupees for the same material without
You read, then I will be able to understand.
Lord, here is the notification option notice. This stated that
I do not know what document it is.
that I'll file the translated document. I'll translate.
Yes. CFEC document.
We have straight away seized the property and put for auction.
Yes.
These methods, the materials, they have been stored at a public place. Will see the impure notice at page 16 on the bank of a river without any permission to store mirror. And the petitioner, he produced certain white forms before the appropriate authority showing that I have been provided with the transit passes to transport such materials. Now I have got the white forms, all the white forms. If my lords will see those white forms, they. First, if I may,
No, only thing is when you are making a search, then in that event, what are the procedures you have to follow? What do you have to follow? Have you followed it? Two independent, reliable witnesses. These persons were there at the time of a search. These are the mandate of section 100 of the Code of Criminal Procedure. And by virtue of this rule, this has to be followed. Have you done so?
That instruction, I do not have.
Take the instruction. I am fixing this matter on Friday. This matter on Friday. Yes.
Item 16.
They have put the option to
Whatever, let them.
16.
Yes. Yes, who is appearing for the petitioner?
Well, as I'm appearing for the petitioner, my lords. Lordships had asked the government to take instructions in the matter. Because, my lords, here what has happened,
Yes.
an NGO, which is a non-profitable organization, has participated in the tender, my lords. They are squandering public money, my lords. They are acting for profit. That is, this is against the tenets of, my lords, the NGO itself.
In this case, we have not received instructions. On the last occasion, the government advocate, learned government advocate was there, he has written a letter. You know, no instructions are come with us, not agreement may be continued.
How short?
Well, fix any date, madam. Follow up.
Friday? Fix it on Friday.
Oblige.
Item 17.
Form of a the petition challenges the election of the opposite party, more particularly opposite party of for the Tahsildar Krishna Prasad, will not take action to construct the building.
Why you are not constructing the public health center?
Public health center.
Yes, what is your stand?
My lord, actually, this public health center is to be constructed within the jurisdiction of a particular Gram Panchayat. My instruction is that, my lord, now there is a dispute between two gram. One is this particular village and another is Muaga, where it is to be considered for construction. Now the Tahsildar has completed the demarcation.
Where?
In Mauja Bajra Court. And now it is being opposed by the villagers of another village. Now it has been referred to the higher authority to find out a suitable place.
No, my lord, Nuaga is not a revenue village. The village, Bhadrakot is the revenue village in which Nuaga is the sublet. Nuaga is not the revenue village. The order has been passed by the CDMO, Puri, that the construction of the building PSC will be constructed in the village Bhadrakot with the Gram. And already your lordship may come to PSC 11 your lordship.
Land is already delivered. Yes, look at it.
Yes.
That already has been located and demarcated. That has been forwarded to the collector. Thereafter, now the problem is the some of the antisocial who have obstructed that land, encroached that land. Again and again, the CDMO, as well as the collector already has.
File an affidavit. The affidavit within 2 weeks after the reopening, rejoinder within a week thereafter. Fix the matter after 3 weeks.
Item 18.
But this is a matter pertaining to blacklisting. I have been blacklisted here, but no show cause notice has been issued to us. My lord, my
Who is the other side?
Yes, my lord.
Where is the other side?
Notice is to
No show cause notice has been.
Where? Show me the order of blacklisting.
The order is in page number 107. It is evident from the order itself that no show cause notice has been given. My lord might be aware of the Supreme Court judgment.
Where is this clause 2.2 of the RFQ?
So clause 2.2 is at page 38. Well, what happened here is that I participate in the opposite party number one tender. I was declared as the highest bidder.
That is reflected there. You were called upon to deposit, you did not deposit, refused to deposit, and then they have imposed. Now 2.2 is if the tenderer reside.
2.2 is if the tender resigns from the offer or varies the terms and conditions / rates after submission of tender, but before placement of order, unless specifically asked for by ISP, the tender shall be treated as invalid.
So it is said that it's automatic, no further procedure is required to be done.
But
you are suspended for a period of 1 year.
For a period of 1 year. I have not been able to participate in any government. It's a civil debt.
No. Only all future tenders of RSP only.
RSP only. That's all.
Suspended.
Suspended and not been able to participate.
Yes,
But
definitely.
this order,
Because you have refused to honor. You have refused.
I have refused.
Yes, you have resigned from the offer.
I have not resigned from my offer.
Then what? Why you are not depositing the money?
Depositing the money in the sense that the allegation they have put here is that I have quoted below the departmental estimate.
No, they have said that you have been found the L1, but you quoted the price very much lower than the departmental estimate based in such and such. You were asked to submit then PGB of amount of rupees such and such against your low court. In reply, you have regretted to submit that. So they also accepted your bid. Even if you quoted the estimate price.
But they say that it's lower than the departmental estimate.
Correct. So it's better. So
that is already. But the prerequisite of blacklisting is that I have.
It's not a blacklisting. It's a suspension.
This order itself that I cannot participate from 1 year. I cannot participate.
This is what is here. They say that you are suspended for a period of 1 year from being eligible to participate against all future tender of RSP. Suspension means what?
I may not be able to.
Only in a paper you are suspended, but you continue doing whatever you want.
So this order will have effect on other tenders as well.
I am conscious of the various Supreme Court judgment that is a kind of a civil death. I am also conscious. Panda projects or infrastructure, what is from Odisha it went.
Services is one of them.
From Odisha it went. There it says.
Telsa is one of them.
So I am conscious, but if that being the position, suspension has been imposed, no mechanism is provided, then what to do?
But show cause is required because what my Lord, please have a look at the Urushian judgment.
Yes.
It says that the principle of natural justice is to be followed before blacklisting anybody. Evidently, they have not done that.
Because it's a suspension. Every case is on blacklisting and a debarment. What is the meaning of the suspension? Now tell.
The reading of the order says that I am not eligible to participate. I am not eligible to participate in any future tender.
There, department is in anywhere you will not be, but here it is restricted to their department.
But this order, because in most of the other government tenders, they say that if you have not been blacklisted or suspended, you cannot participate in this. So this will have this will put a stigma on me. I may not be able to participate in under tender, and they have not issued show cause. My Lord, may please look at paragraph 20 of that.
Have you seen our judgment? Where we took into consideration Erusian, we have taken which?
Arthotran Huilan.
We have taken into consideration the Grossen Pharmaceuticals also, 2001 volume 8 SSC. Then we have
The point remained is that no show cause
this
notice has
Panda
been given.
Infrastructures Limited.
No show cause has been evidently not given. Let
These are these two judgments have been taken into consideration.
might not be
I think
pleased
the Grossen has taken care of erosion.
might not be please look at this judgment of the Gorkha Security.
That was also taken into consideration in Grossen and in the Panda.
Maybe
Panda is of a recent origin. Panda has taken care of everything, all these judgments.
But when no show cause notice has been given, settled law by the apex court itself, when no show cause notice has been given,
No law can be said to be settled.
I approve, sir.
This is Panda is of 2022 volume 4 SSC.
I might not be aware of that.
Go through
But also, my lord, if you look at the
Grossen
headings
is
also,
2001 volume 8 SSC.
well, if we read Annexure 10 again, page
Yes.
107,
Yes, what do you say?
it says that the court is to be very lower than the departmental estimate. So that is why show cause is needed. What is the departmental estimate? They have not mentioned anywhere in the bid document.
Oh, they have simply said that as per the standard terms and condition clause 2.2 and your declaration as per bid, you are hereby suspended. Why you are suspended? Because your quoted price was found to be very low than the departmental estimate on clause such and such. You were asked to submit the PGB, performance bank guarantee, of rupees 20 lakh 60,000.
20 lakhs.
60,000 against your low quote price means they accepted. Please, but in reply, you have regretted to submit this.
Regretted because the reason is that
Reason is that they say that 10% of the reserve price should be you have to give a performance bank
that is not
guarantee.
the point. They say I had quoted 38 lakhs. I was declared L1 bidder. They say that you have to submit performance guarantee of 20 lakh 60,000.
True.
Which is based, they say that our quote is based on lower than departmental estimate.
Sir, what he says is they say that when we have fixed the price or a base price is given, estimated base price. Apropos estimated base price, they say that you will have to give a performance bank guarantee. Even if you quote 1 rupee, if they say that the performance bank guarantee should be of 20 lakhs, you'll have to pay 20 lakhs rupees bank guarantee.
They have not said that in the tender. If you read the clause 2.2, they just say that you have to submit performance guarantee.
Performance bank guarantee of what? Percentage?
Exactly.
Percentage of what?
May I please produce the procurement manual?
What is the terms and conditions? Then I have to give you a lot of judgments of the Supreme Court. It says the freedom of contract to impose any terms and conditions is always there in the tendering committee. You can't say that you cannot put those terms and conditions.
My only humble submission is that
file.
Let's still update the media is
notice.
One point I'd like to submit is that the performance guarantee they have imposed is arbitrary. If they have not revealed the
give notice, let it appear on 9th.
Why not just
9th.
maybe permitted to submit one? It is arbitrary, the performance guarantee. Because the procurement manual.
You have challenged the order of the suspension. You have not challenged the terms and conditions. That's all.
Suspension of type because I have not been properly provided a show cause. What is the department?
We will consider whether it is at all necessary or not. What is that? We'll consider.
Item 19.
But stay, there are every.
Nothing. We are keeping this short notice. Ninth.
Get who?
Ninth. 1 day. Yes.
Item 19.
Come with a line of judgment, sir. It's not so easy that show cause in every case. Yes.
Notification is challenged.
Which one?
19. Sorry.
What is this notification?
This is a notification which state has published, pursuant to which my vehicle was seized. And as per rule 51 and 58, and your lordships have rendered judgment on this as well.
What?
I have annexed those judgments. My vehicle was impounded for alleged illegal transportation of sand. Then therein they gave me no demand notice, which is annexed under Annex 2, my lord, with a penalty of 2 lakhs. And the environmental charges were assessed at 5,000 something, and the value of mineral was 1,500. This notice was published pursuant to the Orissa gas, and this demand notice was asked to me pursuant to the notice of a gadget notice under Annex 3, a gadget published under Annex 3. It was pursuant to Rule 51(4) and Rule 58(5) of the OMMC Rules 2000.
So it is only the court who can impose the penalty, not the office.
I have any lordship judgment as well.
Where is that?
This is
Annex
Rule 51 of the rules. Rules, madam.
Annexure?
Annex 5, lordship of. There was also a party to that.
You are not connected with anything. Yes, what you say?
Now the thing is, Millard, Annexure 3, that is the notification. Actually, Millard, this appears to be a SOP, Millard. In both the cases, Millard, the orders they have annexed, nowhere this SOP was produced, Millard. Also, in other cases,
If the statute does not confer power, by SOP can you confer power?
No, Millard. Absolutely not.
So,
right. So
then-
this notification is confirmed.
Is section 58 and 51 is very clear. Can you?
No, absolutely not.
This is not also statutory notification.
Man.
There is no SRO.
Is
There is no SRO here. Under which provision?
They have only stated imposition of penalty on illegal extraction and
Article 165. Not the one.
so far this notification is file a short affidavit. So far this notification is confirmed.
What?
This SOP is concerned, Miller, because in other cases this SOP was not considered, Miller. And it is a fact that it will not override the statute. We will file short affidavit, short adjournment to be taken.
So that after the affidavit, the matter, the writ petition to be allowed, everything to be quashed.
And that's the first time it is going there.
Give affidavit.
Like,
Vehicle may be reduced.
When it is seized. When it was seized.
June.
So if you have waited for 10 days more, say by 8th, counter affidavit, matter to be listed also. 9th.
Item 20.
The petitioner challenged the rejection of my bid and under Annex 5 at page 30, followed by on the recommendation of Technical Evaluation Committee as per Annex 4, which is found place at page 79. On the ground that the petitioner.
Where is the committee's decision?
My committee decision, my lord, at page 78 and relevant portion at page 79 of my lawsuit.
Which one is your, the Versa?
Three Versa construction does not fulfill the eligibility criteria as per clause number 7 and 112E of the DTC.
Where is that clause 7 and
Page
112?
24, my lord.
Yes?
At page 24. Clause 7 is retail tender conditions towards bottom. Made
Yes.
7. Because the contractors are required to furnish scanned copy of evidence of ownership showing the possession of principal machinery equipments as per Annex 1 in Schedule C, for which contractors shall have to secure minimum 80% of marks, failing which the tender shall be liable for rejection. Subsequent clause. In case the contractor proposes to engage machineries and equipment.
Where is the other 100 and?
At page 45, my lords. Page 45. That is eligibility criteria. Relevant clause 112E. Evidence of ownerships of machineries, equipments as per clause number 7 of DTC.
Correct.
And need to be furnished by.
What you have furnished ownership?
No, ownership which is found place at page 55 of my lawsuit.
Yes.
The petitioner has furnished the certificate of rules and plans regarding the requirement of
These or the ownership, the documents?
Annex lease is Miller from page 51 to 76.
Yes.
Both my humble submission would be Miller, since the requirements have been fulfilled by the petitioner, ignoring their eligibility criteria, accordingly, ignoring that certificate of rules and plans furnished by the petitioner, my final technical bid has been disallowed. And accordingly.
Now, what is your stand?
So far, these documents as per Schedule C was awarded or not, I have to take instruction minute. Because
Are you going for a financial bid?
I will inform the operating field. So far, page 73 is concerned, for example, let's see.
No, I understood your, because they have come up. This is very vital. If they have not uploaded subsequently for the purpose of writ, they have come up. We'll definitely see to it. But prima facie, as it appears from these documents that he has submitted, then you'll have to say that this document is lucky.
Page 73.
Now, are you going for a financial bid?
No, I will inform the operators.
No. Then when you can give us?
1 week.
We are fixing this matter on 10th. They will not proceed with the financial bid. So there is no difficulty on your part.
From 73, what
for my instruction, financial bid has been opened.
Opened? When?
On 18th September 2019, 2025, annual expense.
So what you were doing?
Because they intimated the opposite parties, intimated me on 16th September 2025. Though the committee met on 12th September 2025, but on that day my bid has been rejected, but intimated lately because I could not be able to avail the opportunity to challenge against the illegal action of the tender inviting committee and as well as the tender.
Don't proceed to award the LOA.
So far, my lord's query regarding page 73 is concerned, kindly have a glance to. That is a very vital part of the proceeding, my lord. That is not in the name of petitioner.
What?
Page 73.
You must have taken that on lease.
Page 73. New water tanker. That is in the name of DD Builders Limited, not in the.
No, so they have taken it on lease. Where is the difficulty?
But, I will check out whether these documents are uploaded at the time of submitting the bid.
The certification was there. So, are you disputing the certificate?
No, entire documents.
Then
This series.
So, when certification is there and you have accepted that certification. Because the evidences are lacking, and it could have.
Yes.
Was it your condition that certification would be discarded?
No.
But for
Because
there was other. Have it been so? The evidences, the certification should be supported by evidences.
Yes.
Then it would have been different.
whether it was uploaded or not. That's it is sticking to 10.
Yes, come on.
Item 21. Item not 21.
I'm appearing through VC, my lords. My lords, here the petitioner is a leaseholder of the Jagannath temple, my lords, the quarry belonging to Jagannath temple. My lords, the lease deed is for a period of 10 years. My lords, what I am aggrieved at is, my lords, the collector, even though my application for blasting permission has been was given way back in April 2025, and all other authorities have given their clearance, the collector is not granting the blasting permission. If your lordships will kindly see page 42, my lords, that was my last blasting permission. It was valid till 31/3/25, my lords. Thereafter, my lords, I applied, and all the authorities, competent authorities, they have given the clearance, my lords, to grant me. If your lordships will see page 54. 54 of this. Well, as the Jagannath Temple Authority has said that the blasting permission may be given in favor of the leaseholders. The mining officer, who is the competent authority, he has admitted that I have paid the royalty amount for the financial year 25-26 at page 55, and also recommended that the blasting permission be granted. But the collector is not yet granting orders. It's been already 5 months, my lords. In another 7 months, the financial year will end, my lords. I cannot meet my MGQ, my lords.
That I have put an instruction in this matter. In the meantime, the application for issuance of temporary blasting permission in respect of the following queries are hereby rejected, because there is an order from the Honorable Court.
Nothing has been communicated to me, my lords.
Where is your counterpart? If you appear in virtual mode, how can they give? Give them on a WhatsApp.
I will give. And his name is appearing at serial number 12 too.
Where is an order that no blasting permission can be given?
The past page.
What?
Past page. Towards top.
Oh, no, you say in terms of the order of the High Court, where is the prohibition?
At paragraph 7, it was
These permissions, the applications were pending with the sub-collector.
It was, yes, Milord, it was sub-collector invited the tender. That it was quashed. It was quashed.
That was closed.
Yes, Milord.
That's for Jagannath Temple, competent authority.
Must be at your views.
No. In fact, there is a lot of impact.
Please.
Communicate to it.
Yes.
it is submitted by the additional government advocate that the order of the order rejects.
Service provider. Being dissatisfied or dissatisfying service, the authorities issued letter annexure 1. Your lordship may have a glance to that annexure 1. The second paragraph, 2 lakhs and 20,000 was proposed to be penalized. And challenging that, annexure 2, this honorable court was approached in WPC number 20,245 of 25, and your lordship taking cognizance of the matter, passed an interim order. Paragraph 6 at page 20. May since this order was not extended, now they have deducted 2,20,000 from my dues, annexure 3. Assailing that, I have filed this writ application.
So why you did not mention the matter? Why it is not extended?
It is beyond my knowledge of it has a transport bit to me.
Oh.
Actually, what happened, Millet? The interim order passed by your lordship thereafter did not be extended because matter did not reach thereafter. It deemed to be continued, Millet. Because thereafter matter was not taken up. And we have filed counter affidavit in this case.
So why you have in the meantime started doing it?
No, Millet. He submitted a bill, but he is saying here at page 22, he only alleging that penalty of rupees 2,20,000 is deducted. For what purpose I have to take instruction in this matter?
You have deducted this amount. How can you?
Page 22.
It is deducted. That I have to take instruction. But Lordship directed us to allow him to participate in the bid. We allowed him to participate in the bid.
I have participated.
So deduction was prior to the interim order.
No, man.
The interim order was
for the 2nd of September.
Where do I get it?
Well, there's their signature. This bill is for
this letter.
May to 1/5/2025 to 31/5/2005. Your lordship will find it at annexure 3 page 22. And the signature is last year lordship 29.
No, 31/5. 31/5.
Signature your lordship may at the end.
What end?
Superintendent MKC Medical College, their signature and the date is there.
What?
They certified that claims are satisfactory quality technically and
Sir, this was 31st April 2025 order.
Madam, after lapse of that 4 weeks.
Sorry, no, interim order was passed in July.
This was deducted on this bill was granted on 2/9 and deduction is 2,20,000.
Where is a 2/9?
Well, that signature you also may look at.
Where I am not getting a signature. I'm expanding it but not getting 2/9.
Last annexure 3 last portion.
Yes, please, I am not getting it.
Superintendent,
medical officer stores MKC's Medical College Hospital. His signature at the top.
That is August.
Well, that is, and superintendent MKC Medical College Hospital.
It should be before that.
It is 6.
It is a. One instruction is that it is happening, but this is too.
And it is impossible. It is impossible that after the interim order, if it is a part of the annexure to the petition, and in the petition the interim order is passed, will I accept that this was passed after that? A very layman will understand that.
This is signature is.
Sir, have you not annexed this document with the writ petition?
No, this
Now I am coming. Have you annexed?
No.
Not annexed.
At that time, it was not in.
You are talking about this is annexure 3 and you have not annexed this document in the writ petition.
No, my lord, you need to give that writ petition, your words, I have not annexed.
And thereafter the Vakalatama, that means it is a part of the annexure.
That is your document. This document is yours. Yours. 35. 25. That is your document.
This is, your lordship may look at.
This invoice.
Yes. Is from 1/5/2025 to
31/2025.
My lord.
So
it was what
medical
it was.
officer signed in June 25.
There they have deducted.
That is June. Then we have passed in July.
July, your lordship passed the interim order for 4 weeks. It could not be 4 weeks or until further order, whichever is earlier. Then after lapsing of that period, 4 weeks, on 2/9,
Where is the document? On 2/9 they have done it? Tell me.
Only the exact signature.
No, I am just asking. And now I have come. Your junior has prompted you to say, let us see that what you say is correct. Because it is absolutely a non-application of mine. What is the document you are relying on about 2/9? It is annexure 3 which you are relying? Please be sure. Ask your junior who is prompting you. Is he annexure 3? Then I will come. I'll come. Is it annexure 3? Correct. Come to page 8 of your writ petition. Paragraph 16.
That while the matter should not, petitioner raised his inverse letter fulfillment of dues for the month of May 25 before the appropriate authority who in its turn illegally deducted penalty of 2,20,000 from the said demand raised by the petitioner as his dues in spite of pendency of the aforesaid writ application as well as passing of interim order is by annexure 2 to the writ petition.
So you annex this as a part of the writ petition?
Well, that writ application.
And when the writ petition was affirmed? 14/9. And in this writ petition, the interim order was passed?
Interim order was
passed on 14/7.
Interim order was passed on 31st July. Annexure 2.
Correct. So July, then what remained?
Now that writ application, this impugn order, the illegality of this.
This is another writ petition you have taken out.
My lord.
Oh.
This is after deduction where that was imposed. It could not be for your lordship's interim order. It was not deducted. So for may I give the invoice on 2nd of September, they have deducted it.
Give your response. File your affidavit. 2 weeks, 1 week thereafter.
Item 23.
May I pray, my lord, this may be taken up with that writ application through 20,245. There the counter and rejoinder, everything has been filed.
Yes.
23.
Along with that.
Somebody is there in cabinet, Mr. Misra. Somebody is there in cabinet.
So that was wrong. My instruction is, I also inquired. It was in a different case, a caveat was filed. How it was captured. But the name is
1363 in the office notes.
your state authorities are only.
Next.
Item 23 says.
Lord, here, the petitioner participated in the lottery pursuant to sale notice issued by the collector under Annexure 1. Lord, he was became lottery winner. Lord, he deposited all license fees and other fees. That is about 30 lakhs he has deposited, and he provided the site for operation of the shop.
Liquor shop.
Yes, Lord. It is out still liquor shop. It is not off or on. It's out still liquor shop.
No, whenever you appear, we presume it. It must be relatable to.
Because here it will be manufacture and sell. So, Lord, I provided a site for opening of the shop and for distillation of moha flower. Lord, that was rejected by the collector. Thereafter, I filed an application stating that in that site, for last 9 years, the shop, earlier shop was functioning by other licensee. So there I submitted to the collector stating that I will not sell there, but I will manufacture there. So that was recommended. Collector recommended my case to the commissioner. Now, the commissioner now approved the Annexure 8. Lordship kind of plans.
Then
Annexure 8 approved. Now the superintendent says, the collector and superintendent says saying that for the period from the grant on the date of lottery till date, you pay the license fee and LGQ, entire everything. The commissioner approval is 4/9. I have not operated till date. I have not been granted the license. Where I will operate the shop which has been approved by the commissioner.
How can it be? If the license is granted on a particular day, then how can he?
Not getting it. Yes. Pursuant to order also, before the authority I approves, stating that the license may be granted on 8th September. Till date, they have not issued also license. As per Rule 208, they'll have to give the license, permit license, where I can store the moha flower and I'll go for distillation.
This has to go.
Yes, my lord. But my lord, give me one opportunity to obtain instruction. What has happened? Yes, one opportunity.
Then don't. We are passing an interim order from raising a demand.
My lord, fix a short date. No. I'm not paid. In the month of June, I have paid 30 lakhs. Not a single day I have operated. They have the money with him. Now the commissioner has allowed, but he will not grant the license.
What is the provision?
208 lots. Rule 208.
208. Not keeping well now.
Disposal of application and issue of permit. On receipt of application, Rule 208. This is relating to moha flower chapter.
Yes. And grant him time 2 weeks time after vacation. Yes, call the next.
Item 24.
Entry model, yes.
Publish.
The petitioner found the robust form and manufactures captured feed miners. Pursuant to the advertisement for tender for supply of purchase of cattle feed, Annexure 5, the petitioner along with 3 other 10 bidders participated. They are under Annexure 5, you will kindly have glanced to page 48. Annexure 5. That was the earlier tender. And in that, the petitioner also participated, and a corrigendum was issued by the opposite parties to modify the amount of the turnover as well as the date. This was just done, my lords, to accommodate and to favor the OP number 4, my lords. Because your lordship may kindly see.
What is the stage?
Initial.
Where is the corrigendum? Where is the corrigendum?
Corrigendum, my lord, 58. Page 58, Annexure 5. page 58, my lords. Earlier, the date was 9/4/2025, and it was extended to 29/4, that is column serial number 4 of the said corrigendum, to 29/4/2025. This was to favor the OP number 4, one of the bidder, because your lordships may kindly see the BIS certificate that is under Annexure 7 minutes. Page 62. Page 62 is the BIS certificate. The BIS certificate was issued on 24/4/2025. Within that period, within the extended period by virtue of the corrigendum, which was done by virtue of the corrigendum.
And it becomes successful.
In this, my lords, in this earlier tender, 4 bidders participated. Out of 2 got disqualified, and the present petitioner.
Not earlier tender. Where is the subsequent tender?
My lords, why I am showing this earlier tender? The arbitrary and the biased tender process that has been adopted by the opposite party.
Whatever. Now the present tender.
Now, my lords, the present tender is under Annexure 1. And under Annexure 1, page 15. This is the tender process I have challenged included in this petition, my lord.
Yes.
In this, also, a corrigendum was issued, and wherein the turnover was reduced. Corrigendum at page 26. Technical bid, turnover minimum 20 crores, 5 crores up to 3 years, and 20 crores more than 3 years units. I completed all relevant documents, and the tender was supposed to open on my lords as per the on 9 July 2025. And as per clause, your lordship may kindly have a glance to page 17, clause 7. Page 17, clause 7. Technical bids received online shall be opened on 9/7/2025 at 11:30 a.m. in Umfed Corporate Office in presence of bidders. The bidders who participated in the bid can witness the opening of bids after logging onto the site through DSC.
Then what happened? 9/7.
So we awaited, our representative was there, petitioner representative. The bid did not open on that day.
So,
my lord, subsequently they did not issue any notification. That is under Annexure 2 series. I have given all the email status portal.
Then what?
My lord, suddenly, my lords, under Annexure 3, your lordship may kindly see, under Annexure 3, page 31. They have cancelled, they have rejected my application owing to technical evaluation by duly constituted committee for reason document found not as per eligibility criteria. This was done 2 months after. I was not, as per the clause, my lords, 7, it is supposed to be opened in presence of the bidders.
Issue notice, let them come back.
My lord, now only the lordship may kindly have a glance to page 32. My lords,
Notice on both. Matter to appear.
till then, my lords, the proceeding is stayed because the lordship, they have opened the technical bid.
13.
Dear Lordship, the constitutional validity, that's the amendment provision is under challenge. Lordship, remember this matter before Lordship, which I have quoted the order Lordship, that is on Lordship 18/9/25. Challenging the very same provision of
Procedural rules.
Lordship. And Lordship have issued notice Lordship to them, and it is at confirmed Lordship showed up. By next year, Lordship, they have come up with a further notification in enhancing 2 lakhs to 10 lakhs, Lordship. The same officers, the entire Lordship, they have ransacked the entire institution about state Lordship. Now the officer is more powerful than the chairperson. They will do nothing in the office. By virtue of this order, Lordship, they will enjoy the entire financial benefits, Lordship. And the chairman has no authority to, Lordship, look after the plug Samiti, Lordship, that is the Samiti office. It is that contrary to the Article 243 and their own statutory provision contrary to this.
Yes.
They're challenging the virus of that provision.
We issued notice already.
Let it be tagged.
Which case?
Lordship, that is 23206.
So let it be tagged.
2025. Lordship, it is posted to 16th October, Lordship 2025. I have quoted that order on page 5 of my written application.
Yes. Well,
Can I pray one thing, Lordship? Can there's a fatal
only money for a time being they will spend, we'll take care of it. We'll take back. Don't worry. Up to 2 lakhs, you have no problem.
No, we have problems. That will challenge it.
Anyhow.
During this penalty application, that went up to 10 lakhs.
They have extended it to 12 lakhs.
That's why you have filed second case.
Lost second case.
Yes, call.
My lords, may I just apprise your lordships, there is also a statutory, my lords, amendment. That is why we have also filed another writ application challenging those statutory amendments. That is 25210 of 25. So that may be tagged along with these, but there has been a subsequent amendment.
Yes.
That may be tagged along. I'll give a memo to that effect now.
Next.
The order of last Friday, the Commission of Income Tax exemption in rejecting the revision application, application in complete violation of the section 12A2 the Income Tax Act. Once the trust has got a registration as a charitable institution, whatever assessment pending till that day has to be assessed as per the as a exempted institution. So we come to page. I have quoted that provision, my lord. That is page 10.
The assessment does not depend on the certification date.
Assessment?
Assessment pending.
Pending assessments will be assessed as a charitable institution and exemption will be granted.
Even though that is. It is issued later.
Issued later. Again, proviso of subsection 2 of section 12A. I have quoted it in page 10, my lord.
Page 10.
Page 10.
Preceding the aforesaid assessment.
Provided further that where registration has been granted to the trust or institution under section 12A.
So preceding assessment year, that can be done. Preceding assessment year. So prior.
So this has been clarified, my lord. This has been clarified by CBDT. I have also quoted there. Sir, so come to page 12.
You have any instructions in this?
My lord, here the assessee obtained registration under section 12A from
Have you got any instructions in this? The issue which is raising.
No.
Para 20. Para 20.
Para 20. 8.3. Last 8.3. In order to provide relief to such trust and remove hardship in genuine cases, Section 12 of the Income Tax Act has been amended to provide that in a case where trust or institution has been granted registration under Section 12A of the Income Tax Act, the benefit of Section 11 and 12 said Act shall be available in respect of any income derived from property held under trust in any assessment proceeding for an earlier assessment year, which is pending before the assessing authority,
as on the date of such registration, if the object of the activity is trust or institution in the relevant earlier assessment year are same as those on the basis of such registration has been granted.
So that is what I say, preceding the assessment year means if you are granted a certificate of exemption, say in the assessment year 2009-2010, and if it appears that the assessment of 2008-2009 is pending before the authorities, then it will be deemed that the certificate also applies to this. This is what you want to say. That is what the spirit of section.
Kindly similar annexure 2, my lord.
What do you say about law? Annexure 2, forget.
No, madam, that is approved from 2022 onwards.
Sir, section 12A says that preceding assessment year, it will apply if it is pending. Then how can you deny? How can you deny? What is the meaning of the word preceding assessment year? Preceding means the assessment year, just prior thereto, the assessment year, not unlimited. That will open a big Pandora box.
Just maybe this.
Just years too. Though he will be happy with that. No, sir, can't be. Against the spirit of section 12A. No. Yes. Preceding has to be given a meaning. The second proviso come very clear. Provided further that where registration has been granted to the trust or institution under section 12AA, then the provision of section 11 and 12 shall apply in respect of any income derived from property held under trust of any assessment year preceding the aforesaid assessment year for which the assessment proceedings are pending before the assessing officer as on the date of such registration. So if the registration is granted during the assessment year 2009-2010, if the matter is pending for the preceding means 2008-2009, then in that event it will be deemed that this registration would also. That is the language, very clear language. Why you have confusion in your mind? Brother, I think it's very
This
clear.
is assessment year 21-22. That was pending on the date of registration.
When the registration is granted?
Yes, so granted on 6/11/2021.
So that is the year.
Correct.
He has no preceding. He has on that the very assessment law.
Yes.
He will take his
Stay the demand, let him say, that's all. Stay the demand, let him file opposition, whatever.
Registration code November 21. Date
6/11.
11th
November 2021.
2020. Assessment year.
That is applicable to 2000.
Assessment year is 21-22. Annexure 1.
My annexure.
Item 30.
My Lord, any absence of this?
31.
Because the impugned now the derivative to section 151 capital A and where the entire thing is to be done in the faceless manner. Similar matters are coming up in the manner. Make the necessary correction.
Yes.
Faceless manner.
Yes. 1 to 10.
Jurisdictional officer has done.
Correct. Item 32.
That's it. Here, this picture is challenging this proceeding initiated under CGST Act, whereas the proper officer has, without any independent application of mind, has simply surrendered its power for the AG audit. And as for the dictum of AG audit, he has issued the so-called notice. Kind of a class. Informed notice is at page, annexed 1, page 22. And the relevant portion is at page 23 euros. Para 2.0. Para 2.0 lordship, this is 2.1. This last 5 line, that 2.1 para euros. Keeping in view of the growth of the economy due to the recent construction sector and works contract service, leveraging rise in the revenue variation, this subject specific compliance audit on works contract service has been selected by the Comptroller and Auditor General of India through the Office of the Director General of Audit. Then para 2.2 is the last line, page 44. During the course of audit, the audit team has intimated the following observation. The entire observations have been copied out from the AG audit objection, Your Lords. He has never applied any independent application of mine, and the audit as contemplated under this provision of GST Act is 65, and that has to be conducted by a proper office. So these are the non-statutory authorities. As for the dictate of the non-statutory authorities, the proper officer cannot initiate any proceeding. Entire proceeding is initiated, Your Lords. And Your Lordship, kindly have a glance to the Annex 2, this running page 50, Your Lordship. Annex 2, running page 50. What the proper officer has done here, Your Lordship. Entire verbatim of this AG objection has been quoted in the notice itself. Annex 2, page 50, Your Lordship. So the proper officer is addressing to this assessee and saying only. Your Lordship. This is notice only. Have you replied? No, the page 50 is not a statutory notice. He simply issued an intimation. Annex 2, page 50. Simply saying the Annexure 1 is the notice. Annexure 1 is the Annexure 1, the so-called notice pursuant to the AG audit objection. Simply. Without any independent application of mine, and this division bench of this honorable court under the S12 law, Your Lordship, already is decided this matter. He is relying on the Supreme Court judgment, Your Lordship. Under a different context. No, Your Lordship, the issue is whether the notice, the statutory authorities can surrender or abdicate its statutory discretionary power in favor of a non-statutory authority and completely act under dictate of a southern authority. So this Annex 2, page 50 itself shows, because the proper officer is saying you have to comply to the objection made by the CAG audit, otherwise I will be issuing a notice under section 74. And section 74 says the proper officer, whereas it appears to be proper officer. So the CAG is the non-statutory authority. Every action has to be made by the proper officer and he has to apply his mind independently, Your Lordship. So he has acted as per a dictate of the AG audit, Your Lordship. And under the scheme of GST law, the section 65 provides the audit of books of account. Now here what has happened, Your Lordship, the CAG audit, they are calling for the books of accounts from the assessee and saying you just furnish your books of accounts and I will be examining your books of accounts vis-a-vis the returns. The relevant is annexed 2 page 50, your lordship. The proper officer simply saying you have to comply to the observation of the audit. Otherwise, I will be issuing notice under section 74. And this notice was issued for the multiple period also, as your lordship already admitted. All the paras are the simply reproduction of the AG audit of this in the focus notice, your lordship. Nowhere the independent application of mind or observation made by the proper officer.
What is annexes 1, 2, 3?
Annexure 1 is the impugned focus notice. The proceeding initiated on 74.
Where is that?
It's annexure 1 starts from page 22, your lordship. Page 19 from starts
At
from
the
the
bottom it is annexure 1, 2.
page 22, your lordship. Relevant para is para 2.1 and 2.2. Grounds based on which this allegation has been framed. And 2.2 last para during the course of audit, the audit team. Audit team means the CAG audit team. Audit is already provided on the section 65 under the GST regime, your lordship. And that proper officer who is the authorized person authorized by the commissioner, he has to conduct the audit and form their opinion. And from the para 2.2.1, the entire verbatim copied out from the audit objection, which has been shared by the proper officer as per annexure 2 page 50. What he was seeking reply from the taxpayer saying you have to comply to the CAG objection, otherwise I will be issuing notice with the non-statutory authority. Your lordship, the relevant para of this is the division bench of this.
This Assistant Commissioner GST Central Excise, Cuttack 1 Division.
Your lordship.
Is he not the proper officer?
He is the proper officer issuing SOCAS notice. But this proper officer has to apply its mind independently. He is not supposed to act as per dictate of the AG auditor. How can he? Wherefore he got the jurisdiction to act as per dictate of the AG audit, which is a non-statutory authority. And he's saying he is considered as AG audit observation is the audit report. How can it be, your lordship? And issued SOCAS notice for a multiple period. This division bench judgment of this
for multiple period. So let it go along.
Where is the notice periods?
Period is 2021 and 21-23. Page 22, your lordship. Page 22, and next one that's the impugned SOCAS notice. The fifth line for the financial year 2021 and 21-23.
Multiple notice. Multiple or one notice.
AG audit, because they are roaming throughout the state and
Them come, we are hearing these matters, we'll consider that.
Obliged.
Yes. Well, multiple assessment here by under one notice.
Item 33.
Thank you so much. So challenges the order of adjudication. However, before addressing the adjudication order, Your Lordship, I'd like to bring to Your Lordship notice certain inadvertent errors that has been committed deliberately, probably. Officer, Your Lordship, has passed the order.
Inadvertent error deliberately and consciously committed. So what is the meaning of this word inadvertent?
Your Lordship, that is there in my mind entire time when I had been drafting, when I have been preparing for the matter. I failed to understand, Your Lordship, whether it is inadvertent or it is deliberate, Your Lordship.
Your Lordship, my humble submission, Your Lordship, for interrupting my friend, Your Lordship. Your Lordship may admit this repetition and state the demand, Your Lordship. Let me take instruction.
Yes.
I'm very sorry, Your Lordship, by looking into this order, SOCAS notice, everything I have got. Let me take instruction.
Yes.
Oh, thanks. I'm very thankful for my life senior to be so fair.
34.
Do you mean to say that these auditors are 10?
Lordship, I'm appearing for
Absolutely.
item number 34. Participants.
34.
34
Lordship, I'm appearing for petitioner.
Yes.
Lordship, impugned order is being passed, which is barred by limitation as per section 74, subsection 10 of CGST Act.
Your Lordship,
I would like to draw attention on page
Sir,
29
my
of
interruption, I may be permitted to interrupt my learned senior. This also may be admitted and let me take instruction and stay may be granted here.
Thank you. Yes.
oblige, Lordship, oblige.
Yes.
35.
Lordship, to kindly take page 65 of the brief. Order dated 5/1/24, passed by this honorable court, page 65, annexure query. Petitioner has filed this petition, para 2, seeking to quash order such and such passed by the opposite party under section such and such. Para 3, Mr. Acharya, the counsel, appearing the petition, considered the petitioner was
Remitted to the authority to take.
for a fair trial. The reason was I was behind bars and I never got those offers. So it was remitted for a fair trial. Well, after that, it was remitted. Now, this order is of 5/1/24. 11 months later, on 17/12/24 at page 69, a notice under section 142 was issued, which was followed with another notice at page 73. Let's look at it. Annexure 14. Let's have it. There, at page 75 and the annexure, they asked for certain documents. The details they asked for, and they gave me time of 7 days. Within 7 days, on 24th January, I complied everything. Whatever they asked for, I complied everything. That is at page 77. It's an admitted position. There's no dispute. Then, my lords, at page 80, on 29/1/25, another notice comes to me where they say that you comply extras. There's a certain extra queries that were raised for the first time, and that was said to be complied within 30th January, leaving within 20 hours here. I complied to whatever extent I could. Then, Malaj, I took some time. Ultimately, Malaj, again, there was another notice at page 88, which was complied by me on, Malaj, we'll see page 88. (13-25) to be complied by 18-25. Let's. I gave my reply at page 94. See annexure 17. There, Millards, I straighten out the facts. Everything was submitted, a detailed report, a detailed response was given. Millards may kindly see page 96. On the basis of the above, I further submit my protest as follows. If such was the telling and urgency, then it is not understood as to why a substantial amount of time of more than 11 months was consumed by the assessment unit after the order of remand by the High Court, where when fresh new information is confronted and new queries are being raised at the fag end, SSC deserves a fair opportunity to respond to the same, especially when the information sought for relates to a financial year 16-17, that is around 6-8 years old, allowing sharply constricted time limits. Constricted time limits is in no way a fair opportunity and violates natural justice. Honorable High Court has clearly observed in the order dated suggests that the SSC deserves a fair trial, but not allowing reasonable time to respond to the queries and new information being confronted with,
does not amount to a fair trial. It appears that the assessment is proceeding is being conducted in a pre-decided manner. Hence, I seek 2 weeks for that time to file a detailed response. Well, then I gave a detailed response opportunity given, page 98. At page 98, I categorically state that there are certain documents which are seized by the GST department. I was arrested in a GST case and my documents were seized by the GST department. Whatever is available with me, that I am submitting. And I asked them, Millers will see, kindly see Millers, in further proceedings at page 105, kindly take this Millers, 10.3.25, page 105. Para 3. It is submitted that based on the statement of one Mr. Dipanshu Gupta, the transactions of the SSC with Messrs. Radha Ballabh Export has been put to question without sharing the said statement. What is the incriminating material used against me? That was never shared. I asked for it. Without sharing the said statement of Dipanshu Gupta with the SSC, the present addition is proposed to be made. Your good office may also kindly share the said information with the SSC since no other information is available either with the SSC or with the department. So whatever you are using against me, kindly provide it. It was not entertained. Ultimately, Millers will see at page 112. The assessment order gets passed. For the first time, Millers, the statement of this gentleman, Millers, Mr. Gupta, the statements are Millers photocopied in that assessment order, extracted in that assessment order. So Millers, all the while they had that information, all the while they had that statement, but they never gave it to me. When I'm asking it for again and again, they don't provide, and they straight away pass the assessment order, raising the demand, forgetting Millers the fact that this honorable court directed that a fair opportunity should be given. I therefore, Millers, today I'm on a very limited compass before your lordships. Whatever information they want to use against me, let them provide me. I will comply with the assessment, and then Millers, after giving me due opportunity to be confronted with those documents, then Millers, whatever assessment order they want to pass, they may pass. I am not shying away from the assessment. That is my limited.
Mr. Mahanti, 121. Can you read anything? It is kind of which is forming part of assessment order. Please read.
Extra copy.
Extra copy. You have the copy, 121 page. 121 page is not there with you. It is there.
No, madam, I don't have the copy.
Cannot serve.
It has been served on 16/9/25.
So one extra, I don't have, I think.
Served on
It's the Indian done. This was all done. This document, where you have received full document. What? Tell us.
I'll take this person. I'll take this person.
Then you are chasing him for recovery?
Exactly, because I am facing a consequent penalty proceedings, sir. After the SS.
271.
Yes, that's
automatic.
Although
automatic consequential.
Yes, we informed them that we have approached the High Court. Despite that, they passed the penalty order. Resent to below.
That's very good.
Meaning of a certificate.
Today only.
Should we stop here? Tomorrow. In the serial manner. In the same manner first. Tomorrow. It
I many times know that some share but I don't have the money.